My name is Emily, and I am here with Maya Murphy's attorney, Lauren MacDonald. Maya Murphy has law offices in both New York and Connecticut, and Attorney MacDonald is admitted to practice in both New York and Connecticut. Attorney MacDonald will be discussing expulsion in Connecticut. Specifically, what are my child's rights pertaining to expulsion in Connecticut? Can a school district expel my child for actions related to his or her disability?
Emily, thank you for those questions. An expulsion in Connecticut is an exclusion from school services for more than 10 days and up to 1 calendar year. And a student can be expelled for violating a publicized policy, endangering students or other individuals or property, and also being a serious disruption to the educational process. Under the Individuals with Disabilities Education Act, the IDEA, a suspension in excess of 10 school days constitutes a change of placement. Therefore, before an expulsion hearing occurs, the school district needs to have a manifestation determination hearing to see if your student with a disability can be expelled from school, because the action that occurred could have been a result of the student's disability or the school failing to implement the IEP. If after the manifestation determination hearing determines that the action was a result of the student's disability or the school's failure to implement the IEP, the student will not be expelled. However, if the school does find that the action was not related to the disability and also that the IEP was actually properly followed, then an expulsion hearing will be scheduled and the student will be heard at the expulsion hearing. However, it's important to note that if you think your student may have a disability or has been diagnosed, but the school has not had proper notice of the disability, and your student is facing an expulsion, that be brought up to the school's attention as soon as possible, because before an expulsion hearing, school will need to properly identify to see if your student has a disability, and therefore certain protections should be occurring, like the manifestation determination hearing. Also, if the school finds that your student's actions was a result of their disability, the school may implement a functional behavioral assessment, which is an FBA, to implement a behavioral intervention plan, a BIP, so that the school can properly address the root of the problem that was causing your student's misconduct to begin with. So when the school administration does recommend your student for expulsion after the manifestation determination, in the case of your child having a disability, or just proceeding directly to the expulsion hearing if your student does not have a disability, the Board of Education needs to notify the parents with a written notice of the expulsion hearing within 24 hours of making the determination that your student is up for a possible expulsion. They need to detail the date and time of the expulsion hearing, the actual allegations that your child is being charged with, and also local low-cost attorneys in the area. In addition, the Board of Education needs to give you all the documents that they plan on utilizing at the upcoming expulsion hearing, so that you're not surprised with incident reports, witness statements that you've never received before. Unless it's an emergency, the expulsion hearing needs to be scheduled within 10 days after the school has notified you that they are intending on expelling your student. At the hearing, the Board of Education officer, Board of Education or an impartial hearing officer will make the determination as to whether or not your student should be expelled or not. Also, if they do find that your student should be expelled, they can look to the student's prior disciplinary history. So in the event that your student has been suspended before, has served an out-of-school suspension, they can use that to potentially see what type of punishment needs to be implemented in the future to deter that conduct. After the hearing occurs, the hearing officer of the Board of Education needs to give you their decision in writing within 24 hours after the hearing. And there is no next level of appeal in Connecticut, and basically the Board of Education and the hearing officer's decision on the expulsion is the final say. In Connecticut, there are 2 instances in which a student is mandatorily expelled. The first instance is if a student possesses or uses a firearm, a deadly weapon, or a martial arts weapon on school grounds or at a school-sponsored event. And another instance in which a student is really expelled for up to 1 year is if the student possesses with an intent to sell a controlled substance on or off school grounds. The Board of Education can modify the mandatory expulsion requirement of a student being expelled for 1 year on a case-by-case basis. So if your student is facing an expulsion for one of those 2 instances, it's very important that you speak with legal counsel to see if there's any type of factors or circumstances that could assist your student at the upcoming hearing. So I'd be happy to discuss any questions you may have about expulsions, your students' rights, and any other procedural requirements that the school must meet. So feel free to give me a call.